So why did JP Morgan decide to go through this 5-year process? Well, as many of you will have experienced, if you're a multinational organization in 50 jurisdictions with hundreds of subsidiaries, model contracts soon becomes a very cumbersome process to update. This felt like the way forward. This felt like a more tailored, more flexible approach. So eventually JP Morgan got the buy-in to give it a go. Also, having assessed the local approval procedures for model contracts, it didn't seem like there were that few regulators to bring along with you when you were doing BCRs. And also, if all the regulators were working together, surely that was a quicker, more streamlined process. And in some ways it was. At the time, there was a tidal wave of support for BCRs. Lots of very glowing and positive references from the ICO and from other regulators, from the CNIL as well, saying, this is the future for model contracts, we'll make this work. And with that encouragement and that basis, it seemed like just the time to go down this path. And also, by being one of the first to do it, JP Morgan felt it could influence and participate in the shaping of the BCRs for the future. So, is that how it worked? Well, in some ways, yes. If we look at some of the key requirements of BCRs which JP Morgan had to grapple with, the discussions that they had led to a more flexible approach, which is much appreciated. The concept of having a European headquarters that assumes responsibility for the entire organization's data protection and compliance can sometimes be difficult for organizations. Take JP Morgan. Because of its financial services regulatory background, one line of business within the bank cannot assume liability for another. US regulations say no. And so this had to be explained to the regulators, who understood and said, okay, you can diversify the liability structure so that each individual business line can assume responsibility for its own subsidiaries only. This is an example of the flexibility that can be shown through discussion with the regulators. Again, if you look at the first principles of BCRs, they said third-party liability must extend to all breaches of these rules throughout the world. And again, with discussion, it was clarified that this could just be breaches outside the EU. The BCRs only needed to extend the protection of European laws to those areas where it was not already covered. Very helpful flexibility. Again, the FAQ process being used to great effect. Furthermore, the concept of a burden of proof, which for, if you like, Anglo-Saxon lawyers amongst us is sometimes troublesome. The idea that rather than being innocent until proven guilty, the way it's the same under model clauses, that the concept that if there's a claim against you, you need to prove that this didn't occur. And so we spend a lot of time talking to the regulators about what that meant in practice. What happens if you have a frivolous claimant who keeps bringing unsubstantiated claims? Does JP Morgan have to continue to fight those and substantiate them? It didn't seem reasonable. And again, through the FAQ process, we developed that so that there needed to be some form of substantiation of claim by claimants before this burden of proof kicked in.